Good afternoon, everybody. My name is Nachman Gutowski, and I am joined here with Professor Jeremy Hurley. And today we're going to talk to you about uncharted waters, law school perspectives on generative AI policy making. We are going to go through a lot of stuff, but bear with us. This is going to be our handy-dandy support for the day. You're going to see them. We haven't named them, so if you have any good names, let us know, because we're going to use this a couple of times. But like I said, my name is Nachman Gutowski. Jeremy Hurley. I am the director for academic success programs at the University of Nevada, Las Vegas, the William S. Boyd School of Law. And
and I hold the same title at the Appalachian School of Law, where I also serve as an assistant professor of law as well.
Okay, perfect. So today what we're going to try to do is we're going to try to help understand a little bit the power of generative artificial intelligence. I know we've talked a lot about it, proverbial we, at some of the other sessions today. We're going to anticipate and presume that you have a baseline understanding of what GAI can do. We're not going to talk about that so much, but rather we're going to try to give an idea of policy making at the law school level. What are some considerations? What are some examples? All of this kind of is going to go to examples that we're going to walk through as well. So starting off with potential problems, right? This is what everybody thinks about when it's time to make policy, is the worst case scenario. What can kind of happen? Well, the first thing that we think about is this overdependence on technology. We don't want our students to say, oh, I have a problem. Professor told me to go write a paper. I've got something coming up. I'll just go to ChatGPT, or I'll go to my favorite program. I'll put it in. And then they don't have the ability to do the underlying work. They don't know how to think critically. That's the biggest fear. Another big fear, right? This maintaining originality and critical thinking. We want them, when they are producing material, particularly if it's papers or law review or any of those kinds of things, that it's theirs. And they didn't just put in some kind of prompt, even a good prompt, and just return to you whatever it is that they found on there. And then, of course, the big one, the overarching catch-all, this academic integrity. We want to make sure that what they're producing, what they're submitting, is theirs, whatever that might mean. So this is kind of a baseline of where we are for problems. And we're going to offer a handful of solutions, but this is all just to give you an understanding of what schools are thinking about when they're creating, or what they should be thinking about when they're creating policy. So Professor Hurley, if you want to go through some of the strategies.
Yeah, so in regard to what institutions should be thinking about, we have a few examples here. The first being education about ethical usage. If you've been at any of our conversations about GAI in the classroom and policy making in regard to GAI, generative artificial intelligence, we always resort back to the key being education. That being value of producing your own original work, consequences of plagiarism, and just general ethical usage. Schools should also be focused on the process over product, right? We were just recently speaking at a CLE in Virginia, and we compared this really to a mathematics teacher or professor. Show me how you got there, just don't show me the response. So instructors emphasizing the process in which they resolve legal problems. And then back to developing GAI literacy, that goes a bit beyond education, talking about how we can utilize this as a learning tool for both students and professors alike, what resources are out there, and how to, again, competently and ethically use these programs. And then lastly, another strategy, and arguably the most important strategy for today's session, creation of governing policies, which is what we're going to dive into soon with a little bit of a case-by-case analysis as well.
Yeah, so thank you. So some of the big principles underlying what we consider when we talk about AI policies in education, we have these core principles that we think are important. Things like inclusivity, ensuring that all of your students are able to access, that there isn't a digital divide when it comes to access for financial reasons, or just being able to understand what it is. Equity, privacy, security, all of these things that we have to think about. And the truth is, what we really want to understand is that there's this balance that we have to navigate between this big concept of permissive use. We'd like you to utilize it. We want you to be practice ready. And this prohibitive policy of, we don't want you using it for submitting, for final exams, for whatever it is that your university is thinking about. And so these are all things we have to think about. Well, the way we're going to do this is we're going to look at policies in action. And what we've done is we've identified policies at a lot of universities, specifically law school based, and we've tried to understand what are the policies? What are the reasons behind them? Why would they be doing them? And then how can we think about what those might be? And that's led us to identify some challenges in AI policy creation. And these are things you might think of. Common obstacles have to do with limitations in technology from the university. They don't have the ability to track it. This follows, of course, with lack of training and competence, both at the student level and with the professors, just generally making sure that they're up to date with best practices, which of course is problematic with a technology that's constantly changing. Best practices today may not be what they are tomorrow, and they vary wildly depending on what the institution is trying to do. Going back to those ethical concerns that we talked about. And then, of course, everybody's favorite, resource allocation. All of this costs money. And how do we do that? And how do we have this conversation with our institutions to talk about the importance of this? Well, in order to do that, we have a couple of strategies to overcome these challenges that we'll talk about. But instead of our strategies, we want to kind of identify what are schools doing currently. So let's talk about a little bit about what are schools currently doing.
So on that note, as we began diving into our research, and we've had plenty of help with our research in regard to how institutions are responding to generative AI and combating potential academic integrity issues while promoting innovation within this field, we found in our research and in our writing and just how schools are following their core principles. What are their core principles, and what principles do they wish to uphold in the drafting of such policies? Also, too, another common issue, just an absolute absence of existing policies. And I'm not going to force this to be an interactive exercise, but consider, does your institution have a generative AI policy, and just the general depth of your AI policy? Of course, there are challenges in AI policy creation. The first thing that comes to mind is a lack of voice from all stakeholders, which we tend to see as we dive into some of these policies. Those stakeholders being members of the administration, your students, your faculty members, maybe board of trustees, and especially experts in legal tech that typically can and may or may not have a voice in the creation of such policies. And then we're also going to touch on the future of AI policies in legal education, but mainly focusing on how policies that we draft must be adaptable and must be flexible to change with this evolving landscape that we know of as generative artificial intelligence.
Absolutely. And I just want to add in that it's really important, I think, that everyone in this room and everybody watching, we are the stakeholders, and we should be involved in the creation and the metamorphosis of whatever policy is going on in your university. So Professor Hurley and myself were intimately involved at our own universities in creating the current policy. And we're going to touch on that when we give some examples. But it's really important that people who understand some of the limitations, some of the problems, what are some ways to deal with it, should really be having voices in the room, even though generally we may not all think of ourselves as the people involved with some of these committees with creating the policy, but it's really foundational for us to be part of those voices making some of these changes. So to kind of do that, what we want to do is we want to give you an overview of just select policies from institutions. These are not all the schools that we looked at. We looked at well over 100, and we're continuing to look at some of them. Where's it gone? Did it stop working for me? That's okay. Oh, there it goes. Okay. I must have empty spaces. Okay. Anyway, thank you. These are just a handful of the institutions that we're going to look at. And we chose these for lots of reasons, and they have to do with some of the variance in what they think is important. And so as we were trying to think about this, we said to each other, how do we define this? And originally we thought maybe we talk about permissive, prohibitive, and we found out very quickly that that's too narrow of a definition. And so Professor Hurley was able to come up with a really great way to kind of think about this in a multifaceted way. So I'm going to let him talk about it.
Yeah, absolutely. Thank you. So yeah, as Nachman previously said, almost went into this with a little bit of blinders on. We were looking at the general prohibitive nature of a policy versus the permissive nature of a policy, almost a binary analysis, which really didn't tell us the whole story. But we have expanded upon that, and we've analyzed all of our law schools across the U.S. based on 5 factors, those that have generative AI policies. those being prohibitiveness, in short, just how institutions restrict GAI usage. Then permissiveness, the extent to which institutions allow GAI usage. Educational integration speaks for itself. So how institutions are integrating these tools into their classes and into their policies. Transparency and accountability, that extra measure of reporting GAI usage in assignments and in the coursework. And then the general depth analysis. We added that last factor, and we'll talk about that just a little bit more in just a moment, but we added that additional depth factor because maybe an institution had a permissiveness or generally a prohibitiveness rating that was absolutely off the charts, but possessed very little depth and guidance for students and faculty members. Normally that consisted of about 3 sentences that said, do not use GAI or we're going to put you in jail, right? So I'm going to go through the general rubric real fast. We have a limited time to work through this. But all factors were measured on a 0 to 5 scale. 0 being no mention at all of restrictions on GAI usage. That typically went 0 to 1, really went hand in hand with a high permissiveness rating. 2 being some basic restrictions introduced and outlined. And then as we progressed toward 5, we saw more of a blanket approach. Temple being one of them, which is not included in your handout or on the slides, but one that just said, until we figure this beast out, no one's allowed to use it, right? That would be a really high measure of prohibitiveness. And then next we have our measurements of permissiveness, almost a balancing test between those first 2 factors. But when it comes to permissiveness, 0 being an absolute no allowance for GAI usage under any circumstances, 2 being the some usage of GAI, mostly only with explicit instructor approval. Saw that quite a bit in our analysis. And then as we work toward 5, full encouragement with GAI usage. Now, that was our initial focus, and then we kind of had to expand on that because no 2 policies with the same metrics really look the same. So then we pushed toward educational integration. We tend to see with a high permissiveness rating, we also had a pretty high educational integration rating because they're trying to encourage the usage of GAI in the classroom. 0 was absolutely no recognition of GAI's potential as a resource. 2 was policy recognized the potential of GAI as an educational tool and maybe some steps toward integration, and 5 being comprehensive and innovative integration. As soon as we get through this, I do have some handouts to kind of illustrate that language. And then transparency and accountability, really related to both permissiveness and prohibitiveness. 0 being no requirements to cite the work. That could have been either because there's a really high prohibitive rating, so no one was allowed to use it, so there's no need to cite it. 5 was this comprehensive, clear policies that maybe you can use it or maybe you're encouraged to use it, but either way you should cite it, and there's thorough guidelines and procedures to ensure transparent GAI usage. And then this latter one was created mainly because we had a lot of policies that had similar measurements across the board, but no 2 were quite alike. One might have lacked some depth. 0, we had a few institutions that had absolutely no policy or guidelines provided. And then 5, that other extreme end, being a very comprehensive and detailed policy encompassing a wide range of scenarios, full explanations, extensive guidelines, and maybe some best practices included in the depth. So this is what our chart kind of looks like. We don't really have enough slides to include everything, but this is kind of what the general outline of these metrics would look like. So certain schools like Appalachian, Columbia is your example that you'll see in your handout, having a really high prohibitiveness rating. We'll go through that language in a moment. Permissiveness, you see some schools such as University of Tennessee, University of Virginia, and then we have another one here listed, that being Tulane, with a really high permissiveness rating. Then educational integration, transparency and accountability, and then just general depth. We're going to look here at some of the highest results. Our general prohibitiveness You have two in front of you. You have Columbia Law on the handout, and then the one that I wrote for Appalachian School of Law. Considering our principles, our core principles, and our objectives when drafting these policies, we came up with the following language. So in regard to prohibitive use, students are strictly prohibited from using generative AI, specifically language models such as ChatGPT, OpenAI, Codex, and Google's Bard in connection with graded or required coursework unless expressly permitted by the instructor. This includes, but is not limited to, assignments, exams, research papers, presentations, everything that a student touches. And then we have some language in regard to non-compliance and then how this could lead to severe academic misconduct issues. Again, it's all about your core principles and what mission you're trying to accomplish at your institution. And at ASL, we believe that we needed a little bit higher prohibitiveness, prohibitive policy as opposed to some of these other institutions. But you have Columbia Law in front of you. Feel free to compare and contrast the prohibitiveness in that policy as well. And then we're going to skip down to educational integration for the sake of time, but you have Tulane as an example for permissiveness in front of you. Rather than restricting AI, faculty are encouraged to explore its potential and so on. Feel free to take a look at that. In regard to educational integration, we have one on the board here, and then we also have our example in front of us for USC for educational integration. But for educational integration, you're probably going to see some language in the policy that suggests how you can promote student success by means of adopting GAI, right? And then in this particular example, we have instructor guidance, ethical considerations, workshop and resources, and its application to students. So moving in on the transparency and accountability, we have University of Kentucky on the slide, but we also have UCLA as an example. Transparency and accountability, what we're looking for there with a really high rating was really probably lend itself more toward a permissive policy, but just ensuring the transparent and appropriate use of GAI technologies. And then typically with a really high transparency and accountability rating, there's typically some sort of policy or guidelines with how a student should document or cite usage of GAI.
Yeah, which kind of brings us full circle back a little bit about what is your school doing? So just a quick show of hands, does your school currently that you know of have a GAI policy? Okay. If your school does have a policy, do you agree with it? Ask yourself, do you know when it was made? How easy is it to change it? What were they trying to accomplish? Right? Who was involved in the policy making? Has it taken into consideration definitional starting points? So, you know, some people earlier were talking about integrating things for spell check and for all of these other things that we might call AI, right? AI, like someone said earlier, AI is keeping the plane flying. Right. So if you don't start from a definitional standpoint of what you're talking about, and you can identify, you know, Bard and GPT and whatever as examples, at least we can understand what you were thinking about for large language models and for other chatbots and all of those kinds of things, and maybe some other new things that haven't come out yet. You know, what's really interesting is even places that are prohibitive in nature and that don't want students to use it, they have two additional problems that usually aren't talked about. The first is, do we have the same policy for faculty as we do for students, right? Do we say this only applies to students? Our students can't use this technology, but faculty go right ahead, which can cause problems. So we have to consider that. And then the other thing is there is such integration into everyday life. You know, if you're using Microsoft, their Copilot is in their Microsoft Word. Well, can they use that? If your policy requires them to say, here's what I used, right? If it requires disclosure, and some of the policies do require disclosure, do they have to disclose that? How much do they have to disclose? It becomes a problem of what is and what isn't within the lines. And personally, I'm not a big fan of creating policies you can't enforce. And we don't want to have a situation where students are being told they're violating the honor code, or they are not in compliance with something and potentially are committing, you know, God forbid, the P word, plagiarism, when it's unclear what that is or what the repercussions are. And someone mentioned earlier that all of the tools having to do with identifying, that this was using generative AI. For every tool that there is to identify it, there's another tool that promises it'll help you hide it, and they're not reliable. And so you certainly can't use that to follow up with any policies that you have. And so the other thing we want you to kind of think about is what's the role that you're playing, and then what additional pushback are you getting from your faculty, or what additional pushback are you providing? And you're saying, well, maybe this is good, maybe this isn't. And that kind of leads us down to our recommendations for educators and policymakers. We're still working through some of these. We have a paper that we're working on, and hopefully we'll be able to provide additional recommendations. But the first thing is that we'd like to provide some kind of a framework in order to create these policies. And that has to do, again, like we said, with equity, with access, with accountability, with transparency, with all of those things. There has to be flexibility. You have to think about and build into your program whenever you're creating these policies. How do we update these policies? How do we make sure that all stakeholders, including students, are involved in what these policies say, what they mean? How do we make it really clear what's going on? We want to make sure that we build this kind of consensus, not only at your school, but nationally. What are other schools doing? And we're hoping that by creating this kind of understanding and this ranking system, I hate to use the word ranking, but saying, well, this is high or low on the level of permissive, prohibitive, depth, any of those things that we're talking about, we can say, for our school, this makes sense. For our school, it's okay to have 3 sentences that say you can't use GAI for anything, and that's sufficient. Well, for another school, it may be, sure, you can use it, and we encourage it. And if your professor doesn't want it, they can say not to. And here are the things we define that. It can be much more robust, but really it depends on what you're trying to kind of do from it. We left sufficient time, unless you had anything else to add, we left sufficient time to answer questions. I think I saw one online, but if there's any in here as well, we'd be more than happy to respond. I think there's going to be a microphone coming your way.
Hi, thank you. I was wondering if you've found an alignment between, say, more permissive institutional policies and the role that the institutions play in actually promoting those types of policies like faculty development.
So it's interesting. The short answer is no, but not because we're not looking for it. A lot of times when you're creating policies, we don't have the notes of, we don't have the drafter notes of why we thought about this. And as we were on our own committees at our own universities, I can tell you, I know what my policy at my university is, right? I was involved with other faculty in creating it, but I also know that there's quite a bit that we didn't put in there. And I know that there's reasons why we have commas in certain places and why we think things are clear and why maybe people thought that things weren't clear. And so that stuff's not available publicly. All we're going off of is what's available. I'm hopeful that as people see this and when we push more of our data out, people will be talking more about this publicly so that that exact thing can come out. We can understand why, what are the reasons, what's encouraging some of these actions.
One of the cool things that was immediately apparent when we started digging through all these policies was it was pretty obvious which stakeholder had the most influence over the policy itself, right? Some of them focused very heavily on legal writing departments, right? And then even in some cases, you could tell it was someone who's directly involved with outcomes and assessments. So it was neat, but as Nachman said, we really don't have the notes. We don't know who served on a given committee. But it is pretty neat to see which departments had more of an influence over the development of these policies than others. And sometimes we don't really need those notes to see that.
You had a hand up or you just, no, whoever. I have. Oh, the seat, perfect.
You anticipated that.
Yeah. I have ESPN.
This may be out of scope, but I noticed in the policy examples, there's almost always an exception for an instructor carve out. So my question is, are you looking at how many professors in a prohibitive environment or not, where there's a carve out in a policy, how many instructors are actually explicitly, allowing the use of Gen AI? And I guess conversely, do you see maybe there's a permissive, but you see instructors or professors saying, well, I don't care what the policy is, absolutely not in my class. Are you looking at sort of that instructor-driven approach?
So yes and no. From our own institutions, I can tell you that that exists on both spectrums, right? Because our institutions have different levels. ASL is a little bit more prohibitive. I like to think UNLV is a little bit more permissive, but there are professors we know who will say, no, I don't want any part of this. And there are others who are saying, not only do I want you to use it, we're going to use it in class and I'm going to show you how to use it. Specifically when we're talking about things like legal writing, where they want you to become practice ready and they want you to understand some of those things we heard earlier today about how to utilize it, and that you have to have those underlying skills. From a national level, it wouldn't be possible for us in the timeline. And even with unlimited time, I'm not sure it'd be possible. We'd have to pull everybody's syllabus and then run across it and cross-reference. What I would say is maybe that's a good follow-up, and we'd be happy to support. If you're going to do that, we'd be happy to work with you for it. But it's not currently something we're diving into. Another question? Was there one online?
There was, but it was about how they're accessing the handout, and I was talking.
Oh, okay. Well, we have other things we could talk about for this. You know, I will tell you what's been really interesting when we're pulling this information is trying to understand and realize that some schools' policies are really, really robust. And others, like we said, are just a little blurb, 2 sentences, 3 sentences. But we even found one, is it on here? The one that is just kind of a direction, right?
It's 2 lane, right?
Yeah, okay, so 2 lane, right? So it's on your handout. And I think this one's really, really interesting. When Professor Hurley showed this one to me, I was like, this is really exciting, because it doesn't seem like a policy at first, right? There isn't an enumeration of what's permitted, what's prohibited, how come, all of those things. It just says promote exploration. Rather than restricting AI, faculty are encouraged to explore its potential. Experimenting with AI can help identify which projects can be effectively handled, which cannot. Strategies include requiring students to incorporate personal experiences, cite sources accurately, or compare diverse ideas. I don't know that I would say that that's a policy, but I think that that's a direction. And I think it tells the faculty that we're encouraging you to play with this, and we're encouraging our students to become really, really proficient with it. Did you have a, sir?
Oh, yeah, just more of an observation to follow this gentleman's question. Okay, thank you. I guess it would be interesting to find out in the more prohibitive institutions what and how, or what they're doing and how they're doing it, to enforce that. If they are relying on these unreliable, things that claim to detect AI, or if it's purely the honor system or something like that, it would just be interesting to see data on what they're doing to enforce.
Yeah,
sure. And some policies do, especially those that are more prohibitive in nature. And spoiler alert, there are more policies that are prohibitive than permissive. And I would say the needle is leaning that direction. But I can tell you, since we started working on this, it is absolutely shifting. I wouldn't say that it's completely in permissiveness, the permissiveness corner, but we do see schools that are becoming a bit more open-minded to some of these technologies. But to kind of loosely answer your question, some of these policies will reference Turnitin and some of these other platforms out there, which were formerly only used as plagiarism detectors, that now have GAI detecting softwares and capabilities. But again, it is a little difficult to read between the lines there sometimes.
Yeah, I mean, and I'll just answer just from personal experience on a committee that was talking about this, right? And I made my position clear that having a policy that I don't think you can enforce, or puts you in a quagmire when you're going to accuse somebody of a problem, especially when it comes to the bar exam and all of those kinds of things, the repercussions are pretty substantial and pretty serious. We don't want to just do that. A counter that I heard from people who were in favor of it is, you can create policies to set a tone for what you want for your students, even if it's not perfect how you're going to identify or enforce it. And inevitably somebody's going to do something stupid that makes it very clear, and they're going to hand something in that says, oh, in response to your prompt, here's what I can. And so maybe there are situations where that kind of is. I think we're out of time. We're happy to stick around and answer any additional questions. Thank you very much. If anyone didn't get the handout and would like it, I'd be happy to have extras.
All right, I guess we are good to go then. Thanks. Hi, folks. My name is Mike Bird. I'm a reference and serials librarian over at the University of Detroit Mercy Law School. And in keeping with CaliCon's general theme this year, I wanted to talk to you a little bit about some AI developments I've been tracking for some time now. AI in judicial and litigation analytics databases. Now, a lot of what we've been talking about so far, and I assume that we'll be talking about tomorrow, has been more on the generative AI side of it. But as we'll see, the extractive AI that we've all come to know and love over the past 15 years or so, you know, like starting with basically Westlaw Next back in 2011 or whatever, but you know, before that, that's really been continuing apace as well. And it's really been creating some, like, air quotes, exciting developments, I guess, in the realm of judicial analytics. So that's kind of what I want to talk about. Now, I've been following this stuff for about a year now, and obviously the more user-focused chat body kind of stuff has gotten more attention. Developments in these services particularly have really stepped up what analytics are capable of, and I think we're liable to see them have a huge impact on litigation going forward. So I don't want to wonder specifically whether or not anybody has a unit on judicial analytics in their own legal research courses, but I would strongly encourage you, if you don't already, to take a look at judicial analytics and maybe include it. Maybe just include like a week-long unit on it in an advanced legal research course. I think beginning legal, or I think 1L legal research, there's you need a little bit more context about the litigation process in general to really understand the power of this stuff, but I think it's appropriate for advanced students who've already been through a summer job or so. But yeah, so I think that's warranted. So let's jump in. Anyway, let's get a little bit of background here. One thing I noticed when I started studying this stuff in earnest was that judicial analytics are kind of under-theorized by academics and librarians. Honestly, weirdly so, I thought. When I was doing my initial research, checking what had already been written, I actually failed to turn up really anything beyond basic explanations written in trade journals like Spectrum, or mainly by practitioners, judges, or, like, frankly, marketing executives from the companies themselves. So I think a little bit of basic explanation is warranted in case people haven't encountered this before. So, as we know, when a judge takes some kind of action or decision in a case, really anything, a record of that is produced, right? You know, the most prominent of these records are going to be obviously the published appellate opinions representing a judge's terminal and binding ruling on the issues in a case. But other smaller records are of course produced more or less every time a judge rules on anything. You know, did they grant this motion or deny that one? How long did it take for them to hold a hearing on this specific point? Essentially, everything they do theoretically has a paper trail. And this is data, data that you can collate and interpret to paint a picture of a person. One way that I explain this to my students, to just kind of give them a metaphor, is I remember when I was young, I watched a television show about researchers who went through people's trash and pieced together their lives from, like, bills, junk mail, used toiletries, expired food, so on and so forth. And apparently you could get a pretty good picture of a person's life based on the stuff that they throw away. This is basically the same principle at work with these analytics programs, except hopefully a little bit less smelly. And it matters. Like, it's really not idle curiosity. Since that TV show went on the air, this kind of data gathering to create an analytic profile of a person has become big business, as we know. It's basically the funding, or it's the profit model for both Facebook and Google. They use it for all kinds of stuff, like selling as tchotchkes and influencing elections. But Judicial analytics specifically have their own longer self-contained history for the simple reason that judges themselves as individuals are intensely significant. Like their decisions, their proclivities almost often result in matters of life and death for people, or failing that, millions upon millions of dollars. So creating a profile of a judge from which one could predict their proclivities and behavior has always been a tremendously useful and profitable endeavor, sort of like a pot of gold at the end of the rainbow. And scholars and researchers have been trying to do it long before the internet or with the benefit of any kind of machine learning at all. The earliest published example of this that I could find through my own research neatly lays out the relevance even today. This is from 100 years ago. Charles Groves Haynes's General Observations on the Effects of Personal, Political, and Economic Influences on the Decisions of Judges. Basically a thesis statement for judicial analytics, right? So Professor Haynes reviewed thousands of public intoxication cases brought before New York City magistrates, and he found sharp contrasts in the approaches of different judges along the way. One judge dismissed fully 54% of the public intox cases that he heard. Another judge only dismissed 18%. And a third guy only dismissed one case out of over 500 public intoxication cases that he heard. So yeah, might it be fair, Professor Haynes basically goes on to say in the article, that might it be fair to suggest that the question of whether or not you're going to face the music, I'm paraphrasing here, but whether or not you're going to face the music on a public intoxication charge has more to do with the judge that you were assigned to than anything you actually did while you were drunk in public. Today, this kind of postmodernism is kind of priced into our view of the our judicial system as a whole, but this is 1922, right? This is still well into the era of this sort of quasi-Platonic view of the common law, where it's still sort of believed by a lot of a kind of a bunch of hierophant professors and judges that judges reach into the ether to have the common law revealed to them or whatever. So I imagine when this was published, it was probably a pretty shocking reveal. So the value here is on display, but unfortunately, until computer processing is widely available, this kind of data gathering and analysis to really reveal these trends, to generate the data set necessary to pull it out, it's sort of languishes. It's really just not possible to do en masse. I don't have the information myself, but just napkin math on it means that, or would say that Professor Haynes probably spent weeks, if not months, to generate and analyze these cases just to create one specific data point about one specific type of case in one jurisdiction. It just isn't possible to do for an issue on demand unless you have a computer in play. So it sort of languishes for about 60 years until computer processing and microcomputers become pretty common. And so in the early 80s, Professor Harold Spaeth starts something that some of you all might be familiar with, still going today. It's the Supreme Court database. It's now moved online. You used to send it out in discs, I think, but that's all before my time. But now it's available online. This one's kind of an interesting starting point for talking about modern judicial analytics because it's really based on, it really illustrates what all of these judicial analytics databases that we'll be talking about going forward are based on, and that is metadata. The way that this all works is that individual metadata about a case, that given data point, that filing, that case, that motion decision, it has metadata attached to it, like the judge or the ruling, the date, so on and so forth. And it's through the collation and organization of these databases, or of this metadata, excuse me, that the judicial analytical outcomes become possible. It's really quite simple technically. It really, at this level, it really kind of resembles an online library database, basically Encore for judicial opinions or whatever. But in Spaeth's case, Spaeth and his team of like ongoing interns, volunteers, so on and so forth, what they've done is they've generated their own metadata categories and then hand key it all into every US Supreme Court case that comes out. So they have 60 categories of metadata as of right now that they do. Ultimately coming down to 2,633 total elements or variables or whatever you want to call it. So they go in every time a new case comes out, they hand key in all of these different elements. If they come up with a new element, so it's somebody's job to go back through all of the previous Supreme Court cases to generate these new elements or whatever. It's a lot of work, and it's really only possible with many hands working on a relatively small data set. United States published Supreme Court opinion. Well, obviously they're all published, but United States Supreme Court opinions, right? Anyway, but this is really quite helpful for researchers. It's been a really, like, particularly before Lexis and Westlaw went online, this was a really, really popular thing among academics. But yeah, but it's only possible, again, because the data set is small and Spaeth's got a lot of help doing it. So 20th century closes, 20th century closes on a status quo where the potential of analytics for judges, like the ability to sift through their garbage, if to call it for the callback, it was obvious to most folks, but it was more or less a logistical impossibility, right? The tech was there. Again, like this is just basically an online library catalog system. But what was missing was the data. Like, who was going to go out and collect every single, filing, every single motion, so on and so forth from every judge, and then attach metadata to it that the judge is obviously not doing. Who's going to put in this metadata for all of these millions upon millions of filings and then put them in one database that we can go through and search? And it turns out, as soon as we asked the question, we got an answer. That turned out to be the federal government with PACER. The E-Government Act of 2002 mandated that all judicial filings, all motions, so basically the entire paper trail of federal district court judges be publicly available and searchable via metadata. So basically they gift wrapped us the data set that we needed for a comprehensive judicial analytics database. And the response was more or less immediate. By the time it's compliant and ready to go by 2005, and then a couple computer science pods out in Stanford immediately get to work, and then they have the first versions of their judicial analytics databases. One, Ravel-Law, which no longer exists, and the other, which you have probably heard of, Lex Machina, that is live 2006. So we were all champing at the bit for this to happen. And once it did, the effect was immediate. So once Lex Machina is out there, LexisNexis, as you do, buys it out, buys out Ravel-Law 2, kills Ravel-Law just to focus on on Lex Machina. That goes live on LexisNexis in 2015. The response, once again, from practitioners is immediate. This is an extremely useful tool, which leaves Westlaw and Bloomberg scrambling to put out their own analytics databases to compete on the basic level, which they are able to do because, again, the tech, or once you get access to the data set, the tech is still pretty simple at this point. And then all three of the big three have their analytics databases up and running by 2018, and that puts us into the status quo. It's hard to overstate how popular these analytics systems have become in a short time with major firms. An AmLaw 200 survey, along with Lexis, I believe this was from 2021, said 36% of AmLaw 200 firms currently subscribe to at least one analytics database, and 29% say they're indispensable. That's 29% of the AmLaw 200 firms, not 29% of the subscribers. So virtually every firm that subscribes to a judicial analytics database considers it to be indispensable. They never want to get rid of it. And the result is fairly obvious. It used to be that we had to get a sense of a given judge's activities and proclivities through experience. You used to go and have to ask the senior partner to what is this judge likely to do in this situation, so on and so forth. Now you don't have to do that anymore. Now you can look at an analytics printout, and even better, you can show that analytics printout to your client to properly appraise them of what to expect when you get assigned to a given court. So here, for instance, I have a screenshot from Lex Machina, and this is the Lex Machina report of a judge from my own home jurisdiction, the Honorable Sean Cox, out of the Eastern District of Michigan. We can see the blue is we can see whether he grants or denies a range of different types of motions here. The blue is grant, the orange is deny, the green is partial, and the black line there in the middle represents the national average among judges of whether they grant or deny here. So we can see here that that Cox is pretty close to the national average for granting or denying on most things, except he is far less likely to grant a motion for transfer as the national average. So this is useful information. We can another thing that we can check out. Oh, excuse me. Another thing that we can check out here is going to be the amount of time that it takes him to grant or to dispose of a particular type of case under given criteria. This is obviously really useful for appraising clients of how much they are going to be on the hook to spend in litigating a particular problem. Once again, this is all determined by metadata provided by PACER. Basically, how they do it is what is the date on the opening motion of a given case in this guy's court versus the date on the final ruling, either dismissing or granting summary judgment. Once again, we can see basically they weight it, they bell curve it to let you know how often or how long it's going to take him to put that together. So in both cases, it's derived using this existing metadata, and the system is not adding anything. It's not generating any sort of new information. This is just recalling and arranging metadata that already exists on PACER. And as a sidebar, I didn't really want to get into it too much, but on the state level, this kind of data and metadata obviously exists on the state level as well via state e-filing systems. Obviously, everybody sort of followed along with their own versions of PACER, but that tends to be a little bit more scattershot, as you can imagine, and also retrieval fees are often even higher than PACER's famously high retrieval fees. So it's a little bit more touch and go on the state level and a lot of this stuff, which is why I want to focus on the federal. But rest assured, it is there. Anyway, moving on, here is Westlaw's analytics page for Judge Cox. Broadly similar structure, since again, it's the same data set with the same metadata. However, you will note that the stats themselves don't line up with what we saw before. They're slightly different. The reason for this is because the sheer volume of data coming through PACER, to say nothing of the expense of acquiring it. Again, as we all know, it is expensive to buy up this stuff, even though it's publicly available. It's so vast that not even these analytics databases run by these multi-billion-dollar legal publishing companies can keep up with all of it. Anecdotal conversations that I've had over the years suggest that, like, if you can hit like an 80% retrieval rate on this stuff, you're considered more or less good to go. You can take or leave that conclusion, but we'll see that by and large, this stuff ends up being fairly consistent across these databases, even if their data sets are not always exactly aligned. We can see one thing that Westlaw is doing here is breaking down his tendencies based on motions for the plaintiff versus motions for the defense. This is kind of interesting. We can see that Judge Cox is a little bit less positively disposed to defendants than the national average. I think that kind of lines up with his reluctance to grant motions for transfer. But by and large, he's sort of like just over or under the national average, except for motions for reconsideration. Granting motions for reconsideration, obviously that's kind of like a shot in the dark in most cases, but Judge Cox almost never does it, 2% of the time. So this tells us two things. One, don't bother, don't bank on a motion for reconsideration for Judge Cox. And two, it might be worth digging into those 37 cases where he actually did grant the motion for reconsideration to try and find out like what's going through his head that made him go so far against type in granting those. So this is all like, I mean, it's useful information, and it's not stuff that you could get just by looking at his individual rulings, his individual publication. Last but certainly not least, we have Bloomberg here. In the interest of time, I didn't want to get into Bloomberg too, but I do want to note that for whatever reason, their data set for Cox is a little bit smaller than the others. They're down to 423. But again, we can sort by category here, and it's all, once again, breaks down to all of the same categories as the others because it's based on the metadata. You know, we got the date, motion type, date, and then we have legal topics. I kind of elided this, but we can sort by legal topic based on the suit codes assigned on Pacer. So even the legal topics, it's still based on pre-established metadata. So that brings us to where we were at the dawn of the 2020s. Legal analytics were powerful and useful, but sort of had converged onto a particular format because they are all sort of constrained on this pre-existing metadata. But what if we could write new metadata for this stuff? Like more specifically, if we get away from the technical concept of metadata, what if we could look for patterns in judicial behavior outside of what the court system has deemed appropriate to record up until now? No human being could do this because, again, the sheer volume of work that would entail would make it like functionally impossible. Even if you could hire a zillion people to go back and like track one thing about a given judge, like at some point you got to wonder if the juice is worth the squeeze from a financial standpoint for these firms. But that is, of course, exactly the sort of thing that an advanced AI system, both via a large language model or just an enhanced extractive AI, can handle. So unfortunately, this is where my inquiry and this sort of thing sort of hit a brick wall, because while it's easy to say AI has solved this problem, I honestly can't really tell you how, because that's all going to be proprietary information, right? Like the different ways that people have solved, or the different ways that different firms have incorporated AI into their judicial analytics stuff, that's all proprietary. I've asked, you know, I've asked if you ask anybody, you'll just get press copy, you know. I've asked my Lexis rep about some of the Lexis stuff that we'll be talking about a little bit here. And he says that when he goes to the engineers, he can't even get a straight answer from the engineers. Not that he could tell me the answer, even if he could. So the most I can really do for you is speculate about what these systems are doing under the hood. And my hopefully somewhat educated guess here is that the AI is in fact generating new metadata and retroactively applying it across the existing data set. How much of this is pure generative AI and how much is really careful prompting by human engineers, I couldn't say. But based on what we've already seen about how this stuff works, I think it is essentially working in this new extractive AI manner. So it presents an interesting practical problem where, while we've seen convergence so far, I think going forward, each of these analytic systems is going to develop its own methodology and their own strengths and weaknesses, because nobody can legally share their tech with each other. This is all too new to say exactly for sure what the consequences will be, but some legal problems are already emerging. Right now, there's an ongoing lawsuit from Thomson Reuters against a tech startup called Ross Intelligence that claims Ross is training its legal research AI on a data set it pilfered from Westlaw. The outcome of that, I'm not quite sure, but we got to leave that aside. In any case, we have got at least one mass market example that scratches the surface of what a next level AI-driven analytics suite can accomplish. That is Lexis Context. And it rolled out in 2021. If you've got an academic subscription to LexisNexis, you should have access to context that you can play around with yourself. The press copy on this talks about the patented Lexpressions AI, which, okay, sure. Again, I've asked our Lexis rep about what that actually does. He can't get a straight answer from the engineers. I think what's going on here is that the Lexpressions has been trained on shepherds as well as Pacer, so it can sort of make second order connections from metadata or something like that. Again, I don't know for sure, but what I do know is that context is capable of analyzing the substance of a judge's Pacer-based paper trail, not simply the procedural outcomes. And the result is kind of like I like calling it. So like, it would be like knowing somebody's favorite song before you went on a first date with them. Let me give you an example of what I'm talking about here. Here we have the profile, one part of the profile, excuse me, of Karen Nelson Moore, a long-serving judge on the Sixth Circuit. Context is allow us to track something that really shouldn't be possible with traditional metadata-based analytics here. Not only is it tracking cases that she cites in her opinions, I mean, you could probably do that with a basic language model since the names of the opinions are showing up in the text of her opinions, but it's also tracking the authors of those cases. And I think the results speak for themselves here. If you are arguing in front of Judge Karen Nelson Moore, cite her own opinions to her. And like, that is really just gonna get you through to the finish line. I decline to comment on what this means, but I know if it were me and I saw this, I would frankly be pretty mortified. But in any case, I think it's fair to say that fair to wonder at least if we're getting a picture of her that would not be so easy to paint just 5 or 6 years ago. Yeah. Another example, Judge Richard Berman, a long-serving judge in the Southern District of New York. Interesting trend with Judge Berman is that he barely ever cites United States Supreme Court decisions in his opinions. The only Supreme Court justice who cracks the top 15 with Berman is down here a little bit, Sonia Sotomayor. But you'll recall that Sotomayor served on the Second Circuit before she was elevated to the Supreme Court. So the system's probably double dipping for her. In any case, if you are arguing in front of Judge Berman, base your entire argument on Second Circuit jurisprudence specifically. Don't bother citing the Supreme Court. Yeah. So finally, this is a little bit of a digression here. I don't want to spend too much time on it, but another thing that context does is allows you to track, it dips into news a little bit. Obviously, Lexpressions was trained on the obviously mammoth Lexis news database and has been able to put together news profiles of various corporations and such. So here we have the Ford Motor Company. Some of this stuff is kind of obvious, like the top one here, defective transmission suits, excuse me, that's maybe pretty obvious, but check out down here, the Tata Motors Ford Sanand plant. Going through the thousands upon thousands of news articles dealing with Ford, it managed to create a narrative surrounding the sale of a particular plant to another motor company, in this case, Tata Motors based out of India. So that's kind of interesting. One is free to be impressed by Lexis context or not, but whatever you think of it, I think that we can agree that the stakes for creating an accurate predictive profile of a federal judge, you know, figuring out their ticks, I guess we could probably say, it's the potential rewards here are huge. Anybody who can pull it off is going to be a very rich person. And kind of unlike Minority Report here, that's a Minority Report reference, where the precogs are just sort of predicting the future, the data set for creating this analytic system already exists. It's right there in Pacer, and it's continuously updated for anybody who wants it. Everything a given federal judge has done in a professional capacity since 2004 is right there for the taking on Pacer. And the only question is, what patterns of thought and behavior do we want to look for, and how do we tell an AI to look for it? So, which brings us to Predicta, the Cynics analytics database. Predicta is set up on the Pacer and state e-filing data sets, the same as every other analytics system. It reviews that data for a given judge, and it predicts the likelihood of any given action succeeding or failing before that judge. The twist here, however, is that it does not consider any legal data at all. Like, it does not look at suit codes. It doesn't look at, you know, the motions. It doesn't look at the judge's past behavior based on anything that the judge has done. What it looks at is the demographic behavior of the litigants and their attorneys. It is, you know, like race, socioeconomic status, where the attorneys went to law school. It is a straightforward bias machine. And the company complains the company claims, 85% accuracy. I think Professor Haynes would be proud. Here's the founder, a former trial lawyer who I can only assume has had it up to here with trial judges. We are entirely uninterested in precedent, stare decisis, or even which law is applicable. Instead, we are looking at other factors which are more influential in making a prediction, and those factors are who are the parties and who are the attorneys, because that is ultimately what a case hinges on. That is Dan Rabinowitz, the CEO of Predicta. He's talking on the Legal Rebels podcast. You can look it up. The date on it is May 17th. 2023. It's a pretty interesting thing. And this is gaining traction. It's still pretty new, but just a couple of weeks ago, Quinn Emanuel just picked it up. Quinn Emanuel, if you aren't familiar, they are the largest international business arbitration firm in the world. So they see some promise here. Another contender, hot off a fundraising round earlier this year, is BenchIQ, which claims to be able to predict a judge's jurisprudence based on decisions without looking at written opinions, as well as using generative AI to create a written analysis of said predictions. Basically, what they're trying to do here is predict a judge's behavior based on what they do when they don't feel like they have to explain themselves via an opinion. Just a sidebar here, the founder of this firm, or the founder of this startup, Jimo Biagele, he had previously founded Ross Intelligence, the startup that Thomson Reuters is currently suing for allegedly swiping their data set. On this side, some of they're flush with VC cash right now, but also getting in on the funding round was Cooley LLP, Fenwick and West, Wilson Sonsini. So big firms, powerful firms are getting in on the ground floor with this next level stuff. So what does it all mean? Where's it going? Can a fully AI-driven analytics system like Predicta and BenchIQ actually deliver on their claims? Or is this all just like the Springfield monorail? I don't think anyone can say for sure that any one specific analytics AI holds the key to making an exhaustive psych profile of a sitting federal judge. But I do think that three things are absolutely true. One, and again, maybe most importantly, the data set to train such an AI absolutely exists. The federal district court judge is likely the most professionally well-documented individual in the world. And all of that information is publicly available, if not free, for anybody who wants it. Second is, if such an all-encompassing predictive AI is possible, the technical barriers to making one are now effectively non-existent. Predicta is literally two people. It's Rabinowitz and the programmer he hired to write the AI. Just like with all of the other LLMs we're talking about this weekend, we could theoretically see a constant stream of analytics AIs hitting the market. And I think the only reason we haven't is that you can't really afford to retrieve the data set from Pacer and state e-filing systems without a hefty chunk of cash up front. But that being said, if that money is forthcoming, then we can just keep throwing stuff at the wall until we see what sticks. Third, the first person who actually cracks this code is going to become rich beyond their wildest dreams, if not from just selling this out to firms, or at least like waiting until LexisNexis buys them out for $1 gazillion, and then everybody gets access to it. So, the will is there, and the venture capital to fund it is not that hard to get. So where does this leave us? I have no idea. I could not say. We could follow the lead of the French and make the use of judicial analytics a felony, punishable by up to 5 years in prison. I think maybe that's closing the barn door after the horses have fled at this point. But yeah, I don't know. So kind of a downer ending, but so I know I'm sorry I went over time.
We have a question from someone online. It says, really interesting talk. One question, these differing analytic products seem to report different decision nuances. For example, only one reports likelihood of granting motions to transfer. Are the different platforms doing this intentionally so that we cannot directly compare? Is there an antitrust issue here?
That is a fascinating question that you have caught me flat-footed on. I could not say for sure. I mean, the main reason why they have these different data sets is, again, the practical retrieval issue. There's just so much there's just so much coming through Pacer that it's effectively impossible to stay on top of, without just spending an infinite amount of money on it. That being said, my sense is that since this is all sort of still really new and we're just coming up with new ideas, it could just be a question of it could just be a question of individual innovation that that competitors are free to pick up on. Like, for instance, the issue of like West allowing us to break it down between plaintiffs and defendants, and the others seemingly not being able to. I mean, that could just be a simple question of them being able to. It's just a simple question of Lex Machina and Bloomberg just deciding one day to program that in and provide that service. Which is all to say, I'm not aware of anything that would raise my eyebrows about an antitrust issue. Again, at the end of the day, this is all publicly available information. So, I mean, anybody is free to do with it whatever they want. Yeah.
Thank you. This is fascinating and scary at the same time.
The best kind of fascinating.
So the French approach seems to be potentially a little much. At the same time, this strikes me as a huge access to justice issue, if indeed it will be able to do what it's claiming to be able to do, rather than just being another version of a crystal ball, right? Like jury selection science and all stuff like that. Well, maybe it's not a crystal ball. So if we don't want to go as far as what the French are doing, what other way? I understand that you're saying this is all publicly available, right? But it's clearly, it's like doing legal research in open sources as opposed to utilizing the power of Lexis and Bloomberg and Westlaw. So I'm just wondering if you have any thoughts on, should that be something that a public research institution does? Should that be something that we otherwise regulate?
Well, the main issue, this is something that I actually consider to be this is a ball firmly in the court of but the ball is in the court of the court system on this one, because there's no reason for Pacer to cost as much as it does. Like that to me is itself a pretty substantial access to justice issue. Pacer's bad. We don't really need to pretend otherwise, and it shouldn't be as expensive as it is. If you could lower the cost of Pacer, which again is something that we could very easily do with a stroke of a pen, then it would be indeed very easy to create a public access legal or judicial analytics database. Because again, the tech, at least before we get into the sort of stuff that I was talking about at the end, the tech for the basic stuff is really simple. I mean, it's just a basic, like, Encore level extractive AI. So that should be quite simple to do. And I would be very much in favor of that for access to justice issues. I mean, it's not even necessarily so much a question of like fairness between litigants as it is just a source of general accountability about judges. I feel like the point of the E-Government Act was to allow the public to have easier and better access to the functions of the federal government. And what better way to do that than to use that data to actually create a profile of what an individual human judge is doing. Yeah, and I mean, being able to see it might adjust their behavior, like, I mean, it's almost like Schrodinger's cat, right? Like, I made the joke about, Nelson Moore, like, if I saw this, I would be mortified. Well, maybe she would be mortified too and be like, okay, so maybe I need to cool it on citing my own stuff. It might change her behavior. I think it might change the behavior of anybody with a conscience for the better. I mean, isn't that what calling attention to bias is all about? So.
Thank you so much for your talk. You mentioned Predicta and called it a bias machine. There is and you didn't discuss this, but there is a product for juror analytics out there called Momus.
Momus?
Momus.
All right. I was unaware of that. I will have to look into it.
Yes, I bring it up because they got pushback because they filed a patent on their algorithm for selecting for juror analytics. And even though all their marketing says, in accordance to Batson, that they do not recommend the picking of jurors based on race, gender, et cetera, their algorithm explicitly called out race and ethnicity as negative and positive factors for jury members. So how do these systems, if you're starting to get into demographic data, how do you avoid it becoming a literal bias machine?
Oh yeah, I mean that's there's the rub. I mean, like these things are really a mirror, you know. I mean, it sort of becomes a self-fulfilling. It definitely becomes a self-fulfilling prophecy in terms of like you know if I can speculate as to what it's doing, I mean it's making recommendations of like you know on race or with like the Batson criteria based on prior decisions for that Batson criteria. So it's holding up a mirror to something that has already occurred that we specifically cannot. Oh man. So like traditionally this sort of thing is like the point of this stuff is, as I understand, is like you can't like go on a hunch, right? You know, like the idea of like the nature of prejudice is that like, you know, it's like, oh, everybody knows this or everybody knows that. And it's I mean, when you have an AI telling you that, basically giving you the self-fulfilling prophecy, I don't know. I do not pretend to know what the solution to any of this is. It's yeah, I mean it like again, I mean the French had a simple solution. Yeah, and I mean like maybe for something like that, that's the answer. Like maybe we can talk about outlawing that sort of thing as a result of, you know, existing Supreme Court jurisprudence. But like there's nothing saying that you can't track the prior activities of an individual judge, an individual public figure like that. So maybe the rest of this is all fine. I don't know. I could not say.
I didn't mean to say that.
No, not at all. No, these are important questions. And it's like, and it's all happening right now. So it's an open question as to how we are going to deal with it. I mean, I think that there probably has to, I mean, for stuff like that, I think there maybe has to be some sort of legislative intervention, but I wouldn't pretend to know exactly how we go about doing that. Thank you, everybody.